Okay? Okay, so let's get into it. I'm in True Social, y'all. I'm so excited. Because if I stay ready, I ain't got to get ready. And it's all happening over there. So, okay, so here's the motion, the final motion, the final Judge Chutkan motion. United States of America versus Donald Trump. Protective order governing discovery and authorizing disclosure of grand jury testimony. The United States has moved for entry of a protective order that would govern discovery in this matter. To expedite the flow of discovery material between the parties and to adequately protect certain information that the United States intends to produce to the defendant, the government's motion is granted in part and denied in part. Now, when I did my video yesterday, I told y'all what she said about certain things, and the one thing that she really wasn't feeling was prosecutors was trying to put everything, every piece of material, all different types of material underneath this protective order. But she didn't agree with including underneath this protective order non-sensitive material, right? And so I think that's the denied part, but we'll get more into it. Okay, so government's motion is granted in part and denied in part. And pursuant to the court's authority under Federal Rule of Criminal Procedure 16D1, it is hereby ordered. No limit on already possessed or public documents. 1. This protective order does not apply to information or records that are publicly available independent of the government's productions, nor does it apply to information or records which the defendant or defense counsel came into possession by independent means, unrelated to the discovery process. So if any old body out here can get their information on said material that can be partly connected to this, but not really connected to this, she's like, yeah, we ain't worried about that. Sensitive materials. I guess that would be considered non-sensitive materials. Okay. We're going into a section titled Sensitive Materials. Number 2, sensitive materials, which the United States may designate in accordance with with paragraph 8 below, are subject to this order and may be used by the defendant and defense counsel, defined as counsel of record in this case, solely in connection with the defense of this case and for no other purpose, and in connection with no other proceeding, without further order of this court. So you come across sensitive materials, you can only use that information to provide your defense to, hold on, white women who say not all white. Okay, you can only use the sensitive materials that are related to this case in court or to prepare your defense between counsel and prosecution, that type of thing. You cannot use it to go out onto social media to intimidate a witness, to try to derail this case. No. Moving on. Number 3, under sensitive materials. The defendant and defense counsel shall not disclose sensitive materials or their contents directly or indirectly to any person or entity other than persons employed to assist in the defense. Basically what I just said. Hey, muscles. Persons who are interviewed as potential witness, counsel for a potential witness, and other persons to whom the court may authorize disclosure, collectively an authorized person. Potential witnesses and their counsel may be shown copies of sensitive materials as necessary to prepare the defense, but they may not retain copies without prior permission of the court. She ain't playing. Yeah, you can use the sensitive material. You can use it to, prepare for your defense. You can use it in court. But no, other than that, no. You can use it to prepare your witnesses. You can, whatever you need as it relates to this court and inside this court. Other than that, no. No copies. No copies may be retained by anyone outside of approval from the court. The defendant, number four, underneath sensitive materials. The defendant, defense counsel, and authorized persons shall not copy or reproduce sensitive materials except to provide copies of sensitive materials for use in connection with this case by the defendant. Defense counsel and authorized persons. Such copies and reproductions shall be treated in the same manner as the original. The defendant, defense counsel, and authorized persons shall not disclose any notes or records of any kind that they make in retaliation to the contents of sensitive materials, other than to authorized persons, and all such notes or records are to be treated in the same manner as the original, provided, however, this paragraph shall not apply to generalized mental impressions. You read something and you committed it to memory, not reflecting the content of sensitive materials. So you know how Marjorie Taylor Greene came out and she talked about how she went into a skiff and she saw this information related to Joe Biden and Hunter Biden, and she wrote it all down. She made notes. Then she came out of the skiff and shared all of that information with all of us. She was on Fox News bragging about it. Y'all remember that? That's against the law. In most cases, that's against the law. So same scenario in this situation. Donald Trump comes across some sensitive materials and he take down notes or whatever, or his attorney is taking down notes as they're working through his defense. You can't then take that note page and then go out and share that information with other people. That's basically what that says. 5, under sensitive materials. Before providing any sensitive materials to an authorized person, defense counsel must provide the authorized person with a copy of this order, and the authorized person must agree in writing to abide by this order. So if the court deems you as an authorized person to see this information, yeah, you need to receive a copy of this order so you know the rules. And then you need to sign that you received this order, confirming that you know the rules. Okay, sensitive materials, number 6. Upon conclusion of all stages of this case, all sensitive materials and all copies made thereof shall be destroyed or returned to the United States unless otherwise ordered by the court. The court may require a certification as to the disposition of sensitive materials provided. However, this paragraph shall not apply to any work product, notes, or other documents reflecting the content of sensitive materials. Sensitive materials, number 7. The restrictions set forth in this order do not apply to documents that are or become part of the public record, including documents that have been received in evidence at other trials, nor do the restrictions in this order limit defense counsel in the use of sensitive materials in judicial proceedings in this case, except as described below. The United States may designate the following materials it produces to defense counsel as sensitive materials: materials containing personally identifying information as identified in Federal Rule of Criminal Procedure 49.1. Rule 6 materials, including grand jury, subpoena returns, witness testimony, and related exhibits presented to this grand jury. Materials obtained through sealed search warrants and 2703D orders. Sealed orders obtained by the government's filter team related to this case. Recordings, transcripts, interview reports, and related exhibits of witness interviews and materials obtained from governmental entities. What is Muscles in the chat talking about? Who is Amon Bundy? Who is that? The government shall indicate to defense counsel in discovery, correspondence, or otherwise which materials constitute sensitive materials prior to or concurrent with disclosure. So the government will be the one to say, hey, I'm giving you this information. This is sensitive information. It's not to be shared. Okay. 10. Number 9. Under sensitive materials. Except as provided in this order without prior notice to the United States and authorization from the court, no sensitive materials or information contained therein may be disclosed to any person other than the defendant, defense counsels, person employed to assist the defense, or the person to whom the sensitive information solely and directly pertains, and that person's counsel. 10. Sensitive materials must be maintained in the custody and control of defense counsel. So his attorneys are being given this information, it has to stay within their possession. Can't give it to Donald Trump and Donald Trump go to the house and read it. Can't do that. Right? Okay. Number 10, sensitive materials must be maintained in the custody and control of the defense counsel. Defense counsel may show or provide sensitive materials to the defendant as necessary to assist in preparation of the defense, and the defense counsel is not required to be present while the defendant reviews sensitive information. So he doesn't have, I guess he can take it to the house and read about it. However, Do they really believe if Donald Trump can have access to this material outside of the council, do they really think he's not going to take notes or make copies of this information? I mean, he's not going to do it. He's going to have his people do it. Okay, moving on. However, if defense counsel does show or provide sensitive materials to the defendant, defense counsel may not allow the defendant to write down any personally identifying information as identified in Federal Rule of Criminal Procedure 49.1 that is contained in sensitive materials. So he can't take notes of sensitive material. He can read it, but he can't take notes. And I'm guessing he can't make copies. Where am I? If the defendant takes notes regarding sensitive materials, defense counsel must inspect those notes to ensure that the defendant has not copied down personally identifying information as identified in Federal Rule of Criminal Procedure 49.1. I don't know. I mean, I get the point, but I don't trust Donald Trump's attorneys. I don't trust that Donald Trump's attorneys would follow the law. Look at all of the attorneys that he has prior to this case. All of them have been tied to corruption and lies. Some of them had to get their own attorney in dealing with Donald Trump. They are being charged with crimes. So for an attorney to know all of this and still step forward to represent Donald Trump, I don't trust you as an attorney. I believe you are just as corrupt as Donald Trump and all of the attorneys that have come before you. Somebody says, Chris, you getting on my nerves. I got him. If he getting on your nerves, then I guess he getting on mine. He gone. He gone. Y'all get what I'm saying, though? Back to the attorneys. Y'all get what I'm saying? If I was an attorney and I saw all of the corruption that was swirling around Donald Trump, and Donald Trump came to me to represent him, there is not enough money in the world. There is not enough money in the world. Because I don't even want to be viewed as someone who is unethical. Because I'm sure I'm not the only one that views these attorneys as unethical. I'm sorry. Let's keep going. Moreover, during any time that the defendant reviews sensitive materials outside of defense counsel's presence, the defendant must not have access to any device capable of photocopying, recording, or otherwise replicating the sensitive materials, including a smart cellular device. So if he does have this information and he's reviewing this information outside of his defense counsel, say his defense counsel had a court hearing or they met with the prosecutors and they received some sensitive information. Donald Trump is on the road at a rally and they say, we need for you to look at this, look it over so we can do a quick chat about it. And they fax these documents to Donald Trump wherever he is at his rally, right? Donald Trump is supposed to read the documents, right? And have his little chat with his defense attorneys so that they can strategize their next move, all about his defense, right? And so we're supposed to believe that Donald Trump is then going to take that fax copy, shred it, burn it, rip it up, trash it, and do nothing with that. But I guess a fax would be a photocopy. That would be considered a photocopy, right? Donald Trump. And if Donald Trump shows proof that he can't fax, Joanne Stocker says he can't fax. Okay, technically he can't fax. Okay? We know there is a strong possibility that could happen. So we're going to believe that wherever Donald Trump is, he's not going to have some flunky around him and say, flunky, take a screenshot of this. Or flunky, fax this to my home office. We think Donald Trump's not going to do that? Because clearly he still has people around him that will allow him to use them. China Doll says, I'm just wondering who's going to read it to him. Baby. Oh, I know what that is. Okay. This is what's swirling in my mind. I mean, all of this sounds nice. I think it would have been better to just have it. Donald Trump cannot be alone with these documents, period. These documents are not to be in Donald Trump's possession outside of his attorneys, period. Because there is just so many different scenarios that could happen for Donald Trump to duplicate these documents. Defense counsel must also ensure that all sensitive materials are collected and safeguarded when the defendant is no longer reviewing them. We're still on sensitive materials, number 11. The parties may include designated sensitive materials in any public filing or use designated sensitive materials during any hearing or the trial of this matter without leave of court if all sensitive information is redacted and the parties have previously conferred and agreed to the redactions. No party shall disclose unredacted sensitive materials in open court or public filings without prior authorization by the court, except if the defendant chooses to include in a public document sensitive materials relating solely and directly to the defendant's personally identifying information. If a party includes unredacted sensitive materials in any filing with the court, they shall be submitted under seal. 12. Under sensitive materials. Any filing under seal must be accompanied by a motion for leave to file under seal as required by the local rule of criminal procedure 49F6I, as well as a redacted copy of any included sensitive materials for the clerk of the court to file on the public docket if the court were to grant the motion for leave to file under seal. Okay, scope of this order. Modification permitted. Nothing in this order shall prevent any party from seeking modification of this order or from objecting to discovery that it believes to be otherwise improper. No waiver. The failure by the United States to designate any of the materials as sensitive upon disclosure shall not constitute a waiver of the United States' ability to later designate the materials as sensitive. No ruling or discoverability or admissibility. This order does not constitute a ruling in the question whether any particular material is properly discoverable or admissible and does not constitute any ruling on any potential objection to the discoverability of any material. Challenges to specific documents. The defendant may raise particularized concerns about specific documents by motion to this court. So, that's the final protective order that was approved by the judge. It covers a lot. And if Donald Trump wasn't Donald Trump, it would be satisfying to me. But yes, Mamie, I'm back. I had to create a new account. If Donald Trump wasn't Donald Trump, I would be okay with it. If Donald Trump was a law-abiding citizen who wasn't steeped in his privilege, but Donald Trump is Donald Trump, steeped in his privilege, believes that the laws don't apply to him. He has never had to follow any rules, and if he did, he always broke the rules and never received any type of consequences. How long do y'all think before he violates this protective order? Joanna Stalker, I have seen many comments that this is a setup for Donald Trump. I do believe his attorneys came out. Let me Google. I do believe that his attorneys came out and said that this was a setup. Let me Google and see what comes back. I guess I gotta restart. I'm not doing that now, but I haven't seen anything from Trump's people in regards to the order. Tab, had scheduled a live for August for Republican debate. Will that be here? Yes. Let me schedule it right now before I forget. Let me schedule it right now. Okay? I told y'all. Okay, I love y'all. Y'all be safe out there. The numbers for COVID are rising again. So beware. Put your sanitizer in your purse. Okay? Okay. I'll see y'all later. Y'all be safe. If I could get out of this. Wrong way. I gotta. Oh, it's down here. Child, I can never get out of this. Never. I can never get out of it. I might have to shut down the whole and it's giving me the instructions. There it is. All right, y'all. I'll see y'all later.